Extradition treaties are legal instruments based on sovereignty, reciprocity, dual criminality, and mutual legal assistance. They ensure the orderly transfer of individuals accused or convicted of crimes between states while respecting international law, human rights, and diplomatic relations. Key principles, including state sovereignty, mutual cooperation, and reciprocity, form the legal basis for an extradition treaty under international law and diplomacy. According to international law, every state has the sovereignty to decide whether or not to enter into an extradition agreement with another country. Thus, the decision to cooperate on extradition is voluntary and based on mutual consent, typically formalized through treaties or bilateral agreements. This is because extradition treaties serve as binding agreements that provide the legal framework for the process, ensuring that both parties agree on the scope of extraditable crimes, the extradition process, and the rights of the individuals involved. Extradition is often based on reciprocity, meaning states agree to extradite individuals for similar offenses to each other. Thus, the extradition of a fugitive is typically a two-way commitment, where each country is bound to reciprocate the other's request for surrender, provided certain conditions are met. Dual criminality is a key principle in extradition. This means that the act for which extradition is requested must be a crime in both the requesting and requested states. However, extradition may be denied if the alleged offense is not recognized as a crime in the requested country. One key point to note is that international law fully acknowledges the non-extradition of political offenders. However, it generally prohibits extradition for political offenses, example, dissent against the government, political activism, or acts related to national liberation. Treaties often stipulate this to avoid the misuse of extradition for political persecution. In Sierra Leone, for example, the Extradition Act of 1974 remains a cornerstone of the legal framework for the extradition of criminal suspects to and from the country. As international crime and cooperation evolve, the Act provides a structured approach to handling requests from foreign governments while ensuring the protection of fundamental rights. The Act defines a fugitive criminal as any person accused or convicted of an extraditable offense who has fled from the jurisdiction of a requesting state. According to Section 3, every fugitive criminal is liable to be apprehended and extradited in the manner provided in this Act. The procedure for extradition in Sierra Leone is straightforward and uncomplicated. Extradition requests must be addressed to the Attorney General through diplomatic channels. Section 6 states, a request for the surrender of a fugitive criminal of any country shall be made to the Attorney General by a diplomatic representative of that country. Upon receiving such a request, the Attorney General determines its validity before initiating legal proceedings. As discussed above, one of the fundamental principles of the Act is dual criminality, meaning that the offense in question must be recognized as a crime in both Sierra Leone and the requesting country. The law also stipulates that extradition shall not be granted for politically motivated charges. Section 10(1) clearly states, extradition shall not be granted if the offense is of a political character or if the request is made for the purpose of prosecuting or punishing a person on account of his race, religion, nationality, or political opinions. This safeguard ensures that the law is not used as a tool for persecution. Follow Global Post News for more updates.